This is Freddy Laurente. He works as a painter for Helenar Construction. Laurente alleged that he is a regular employee doing work that is necessary and desirable for Helenar Construction. Specifically, Laurente continuously performed tasks as a painter in Helenar Construction's various project locations. Later, Helenar Construction's foreman required him to sign a labor contract for a period of 3 months with a clause stating that his employment would be renewable depending on the evaluation of the site engineer and foreman. Laurente refused to sign the contract because it would violate his security of tenure. Subsequently, Helenar Construction's project in charge barred Laurente from entering the construction site. On the other hand, Helenar Construction and its registered owner, Joel Argarin, countered that Laurente is not their regular employee. Rather, it was their subcontractor who recruited Laurente as a painter for the project. Moreover, it is a practice in the construction industry that subcontractors are hired for the flooring, ceiling, painting, electrical, and other related services. They likewise claimed that Laurente refused to sign the labor contract that they prepared and unjustifiably stopped reporting for work. Consequently, Laurente filed a complaint for illegal dismissal with money claims against Helenar Construction and Argarin before the labor arbiter. The labor arbiter held that Laurente was a regular employee of Helenar Construction and was illegally dismissed from service. Helenar Construction and Argarin appealed to the National Labor Relations Commission. The NLRC reversed the labor arbiter's findings and declared that no employment relationship existed between Laurente and Helenar Construction. The Court of Appeals affirmed the NLRC's judgment. Laurente sought reconsideration but was denied. Is Laurente a regular employee of Helenar Construction? The court ruled in the affirmative. At the outset, the court stressed that what determines regular employment is not the employment contract, written or otherwise, but the nature of the job. The applicable test is the reasonable connection between the particular activity performed by the employee in relation to the usual business of the employer. Apropos is Article 280 of the Labor Code. Clearly, the standard supplied by the law itself is whether the work undertaken is necessary or desirable in the usual business or trade of the employer. This can be assessed by looking into the nature of the services rendered and its relation to the general scheme under which the business is pursued in the usual course. In this case, Helenar Construction and Argarin are principally engaged in the construction business. Laurente, as a painter, is tasked with preparing, sanding, and painting various construction works. Inarguably, the nature of Laurente's job required him to perform activities which were deemed necessary in the usual business of Helenar Construction and Argarin. As the labor arbiter aptly observed, Laurente's duty is relevant to the core of Helenar Construction and Argarin's business. Indeed, Laurente's continuous rehiring to different construction projects of Helenar Construction and Argarin from April 2012 until his termination in November 2014 attests to the desirability of his services.